Or don't start.
Inside? No.
Yeah.
No. Right here. And stay in, they won't go out.
Greetings, 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 greetings. It is I, King Clifford Jefferson, our Senator Godfrey, the fifth kind of band Jew, the son of folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ. It is August 15th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of my Queen, Sister Godwinson from the House of Godwinson. I greet you in the name of my Archbishop Belmont from the House of Belmont. I greet you in the name of all officers, members. I greet you in the name of the elders, forefathers, ancestors, successors, heirs, predecessors, and all the above. This is part two, The Crown, New Jersey's capital, the stolen secrets revealed. Once again, part two, The Crown, New Jersey's capital, the stolen secrets revealed. Please subscribe if you like to the Third Timothy English Church of England, as well as donate your free common soakage to the Third Timothy English Church of England or $ Clifford Jefferson L, as well as we're open for all live broadcasts on any platform who's open to the dialogue. It's very prevalent to this day and time because a lot of us are, from my point of understanding, are ignorant, are unknowledgeable about what it is that they so-called say they have in relationship to their due process of law or their legal status. All right. This has not been discerned by any person that I've seen deemed to be able to discern anything. All right. And I'm going to break it down to you again for all those who have raised themselves up to the level of cognizant. All right. If you're able to comprehend this lesson, then that means that you are in fact and indeed cognizant about your present situation. If not, that means that you are not aware and therefore you're subject to what they call a downfall, which has always been the case in any nation, the downfall of a nation. Everyone's searching for their nationality, everyone's searching for their country, everyone's searching for their land, everyone's searching for their protection at law, everyone's searching for their lost estate, their inheritance, all right? But no one actually dealt with nationality, okay? Being part of the nation, all right? Pledging your allegiance to a nation, a country, a head of state, on behalf of your part you play as being one of the people, okay? So this is part 2 of The Crown, New Jersey's capital, the stolen secret revealed. All right, please pass the information on to those who are cognizant. If they're not cognizant, then it doesn't mean, it means that this information will do you no justice. All right, if you go around, look at all the platforms that's out there, claim to be cognizant, and none of them thus far come close. All right. So without further ado, let's get started. We're going to start from, once again, the 1911 encyclopedia. Very, very important. We use that Encyclopedia Britannica as an attestation to our conclusion, which was drawn from our premises, which is based upon all the statements, all the facts we presented, based upon the abstract idea of us claiming to be heirs or descendant of people known as Anglo-Saxons. Okay? I just do the Berbers on it for the sake of the argument. All right? There was no people, based upon any person who claimed to bring awareness to a people about their identity and reference to a nation being incorporated with other nations and a uniform body of politics based upon the social contract, no one have ever incorporated the Berbers. Okay? Every other nation has been incorporated except the Berbers. Very important we understand that. I'm the first person to come up with the concept of Anglo-Saxon Berbers. Very important you understand that. Anglo-Saxon Berbers. I always say, he who writes your books set your timeline. Time never was when man was not. If the life of time when man begins, the time will come when there will be no more. We can read all we want about the Berbers based upon religion, tradition, custom, characteristics, but all of those concepts or arguments or premises are for naught without a government to facilitate it. Okay? Without a government to facilitate all the above. (1911) Encyclopedia Britannica, written by employees who worked for the Encyclopedia Britannica Company, which was a company started in Edinburgh, Scotland, in the 17th century. And the Edinburgh, Scotland was the platform or the seat of government or the itinerant government in which the Scottish kings drew their conclusions from, right? Which was the foundation for the colonies as well as you call the states. All right, all this must be put forth in the equation, based upon a government, because some governments are not de jure. Some governments are de facto, and the de facto government is basically called a provisional government or a temporary government, and their departments and their agencies are temporary, provisional. All right, very important you understand that basic knowledge. So we see here in the 1911 encyclopedia talking about the Berbers, which were ancient Libyan uh, characteristics of people who lived in North Africa. All right, who lived in North Africa. All right, if these people live in North Africa, then they must have been a part of a nation, and the nation is governed by a government. And they're referenced in the 1911 encyclopedia, which is primarily one of the oldest encyclopedias worldwide used. And prior to the 18th century, it was the only encyclopedia to be used in regards to some type of historical premises. All right. It says the Berber village is his state, and the government is vested in the assembly. The Jimna form of all males old enough to observe the fast of Ramadan. For them are determined all matters of peace or war, legislation, taxation, and justice. The executive officer is the Amin, a kind of mayor elected from some influential family, and which the dignity is often and practically hereditary. So we know that the government is basically from the lowest level is ran in your municipality. That's what they're talking about. You got the state, and the state has within itself the municipality, which is the original where you can see the government sits in the city, within the county, within the state. Okay, and we're talking about the equivalent to what the Arabs call, based upon their tribal customs, because they were a desert people. They never had a democratic government like they're speaking about that of the Berbers, which was called Jimna. Okay, which we'll talk about in 1 second. The executive officer is the Amin, a kind of mayor elected for some influential family, and which the dignity is often in practice hereditary. He owes his position to the good and will of his fellows, receives no remuneration, and resigns as soon as he loses the confidence of his people. Okay? Very, very important. And we're talking about Berbers. We're not talking about Arabs. We're talking about Berbers. So the terms you see as Jimna and Tamnin, those terms are used for Muslims or Arabs, okay, based upon their particular cultural, tribal laws that govern them. Contrast to that which is disguised by Dr. Dr. What's his name? Dr. Robert Gordon Latham, who is the ethnologist, okay? Very important. Let's see the distinction he makes before we go further. Right here. These are my sources. Dr. R.G. Latham, let's look who he is first before we get there. Oh, I'm sorry, I'm not even showing. Right? Dr. Robert Gordon Latham. Robert Gordon Latham, 24th of March, 1812 to the 9th of March, 1888. All right, he was a member of the Fellowship of Royal Society, all right, which is a society in London. the eldest son of Thomas Latham, Vicar of Billingborough, Lincolnshire. He was born there on the 24th of March, 1812. He entered Eton's College in 1819 and in 1829 went on to King's College in Cambridge, where he graduated with a bachelor's in 1832 and was soon afterward elected a fellow. Okay, so this is the ethnologist and the philologist. Okay, a philologist studies language and oral and written historical sources, and the ethnologist studies and analyzes the characteristics of different people and the relationship between them based upon their genetics, genealogy, or ethnicity. Everybody understands that, okay? So let's go back to the 1911 encyclopedia. The 1911 encyclopedia. And the question, please post them in the chat. If anybody joins me in the chat. Dr. R.G. Latham, the first, just the individual we reading about on Wikipedia, writes, all that is not Arabic in the Kingdom of Morocco. All that is not Arabic and French province of Algeria. So they're not talking about Algeria, because they're going to be talking about French possessions in Algeria, and all that is not Arabic in Tunis, Tripoli, and Fezan is Berber. Okay, I repeat. Dr. R.G. Latham, who writes all that is not Arabic in the Kingdom of Morocco, all that is not Arabic in the French provinces of Algeria, and all that is not Arabic in Tunis, Tripoli, and Fezan is Berber. The explanation lies in the profound distinction of character, ethnicity. The Arab is a herdsman and nomad. The Berber is an agriculturist and a townsman. The Arab has built his social structure on the Quran, which inculcates absolutism, aristocracy, theocracy. The Berber, despite his nominal Mohammedanism, is a Democrat with his Jimna or Witimat and his Qanun or unwritten code, the Magna Carta, of the individual liberties as opposed to the community's good. Greetings, Archbishop Mount from the House of Belmont. So the Berbers' government was actually called Witimat, and the laws of the government were called the uncoded Magna Carta. Okay? Right here. Two focal points. Witimat and Magna Carta. Both of these terms are terms related to the government, and they all were practiced by Berbers as qualified by the 1911 Encyclopedia Britannica. Okay? The Encyclopedia Britannica. All right? They never called them Anglo-Saxons in the 1911 Encyclopedia Britannica. But they did say the Berbers government was called Witimat, and they had an uncode of law called the Magna Carta. Now let's see the prophecy in this fruition. Okay? Let's see the prophecy in this fruition. So if the Berbers government, i.e., was called Witimat, and the Magna Carta was the uncoded law that they went by concerning the Berbers, and there's no mention of anything about Anglo-Saxons, and this was recorded in the 1911 Encyclopedia Britannica, then let's see if we look up Witten or Witimat in Wikipedia, let's see, do we see the word Berber, okay? Let's see if we see the word Berber associated with Witten or Witimat, because according to the 1911 Encyclopedia, that's who they say they were. They say they were Berbers who practiced Witimat. So let's look up Witten. Basic mathematics. 1 + 1 = 2. The Witten, wise men, was the king's council in the Anglo-Saxon government of England before the 7th century until 11th century. So the 1911 Encyclopedia is validating that the government of Witten was a practice, as well as the uncoded Magna Carta was the laws practiced by the Berbers, who was called Wittenmont, and the Magna Carta. And we see Witten, as they say here, is the code council of the wise men of Anglo-Saxon government of England. Now that's a prophecy right there, because nowhere did it say in the Encyclopedia Britannica that they were of Anglo-Saxon descent associated with the government of Witten. It says the government of Witten was associated with Berbers, and no one from the time of the Anglo-Saxons, according to the story being told by others, are affiliated with Berbers. Okay? The 1911 Encyclopedia never called them Anglo-Saxon, but they did call them Berbers with Witten, and no other scholar or historian are going to associate Witten with Berbers. Okay, until I did it, till I made the connection. Now we read the 1911 Encyclopedia, and I didn't even know that when I incorporated this government. All right, based upon our ancient laws. Witten Wiseman was the King's Council and the Anglo-Saxon government of England from before the 7th century until the 11th century. It comprised of important noblemen, including aldermen, things, and bishops. Meetings of the Wittens were sometimes called Wittenmont, the same government laws that were ran by the Berbers. Okay? And they're saying that the Anglo-Saxons had the same type of practice. And prima facie function was to advise the king on legislation, judicial cases, land transfers, and other matters of national importance. The Witten may have elected new kings from among members of the ruling dynasty, but after the Norman conquest in 1066, this role was performed by a similar council known as the Curia Regis. So the paramount or the first government structure that was created for the Berbers was called Wittenmont until it changed to the Curia Regis and then to become what we call the King's Bench. Okay? Origin. Okay? Witten or the Curia Regis. All right? Witten or the Curia Regis. It was called Witten, then it became the Regis, then it became what they call the King's Bench, which brings us here, the Court of the King's Bench. The Court of the King's Bench, formerly known as the Court of his Kings before points out. The Court of the King's Bench, formerly known as the Court of the King before the King himself, was a court of common law in the English legal system. All right, that's what you call it today. Created in the 12th and the 13th century from the Curia Regis. That goes back to William the Conqueror. Prior to that, it was called Witten or Wittenmont, which according to the 1911 Encyclopedia was the government of the Berbers. Okay, as told and written down. I didn't come to change the law, but to fulfill the law. So if the law said, based upon what the kings of Scotland said in their record called the 1911 Encyclopedia, that the government and the uncoded law of the Magna Carta was based upon the laws of the Berbers, that means that those who practiced this system were those who called it by other names, called the Curia Regis and the King's Bench, or the Court of the King's Bench, or the Court of the King before the King himself. Okay? Very important. Let's go down. Got a lot to cover. Origin. Origins of the King's Bench, or the Curia Regis, which we know is called Wittenmont. Originally, the sole court was the Curia Regis, one of the three central administrative bodies, along with the Exchequer and Chancery, from which the Court of Chancery was formed. This Kuray was the king's court, composed of those advisors and courtiers who followed the king as he traveled around the country. This was not a dedicated court of law, meaning that it was not stationary. Instead, a descendant of the Kuray Dusias and partly of that of Wittenmont. Okay? The concept was the Kuray Regis every circuit staffed by itinerant judges, dispensed justice throughout the country, operating on a fixed path at certain times. These judges were also members of the Kuray and would hear cases on the king's behalf and the lesser Kuray Regis. Because of the Kuray travel with the king, there were problems with the administration of justice. For example, if the king left the country for an extended period of time, as Richard I, son of Henry II, son of Henry II, son of Godfrey V Caliban Jew, would spend the vast majority of his reign overseas did, the Kuray followed, making hearings difficult to hold. To remedy this, a central bench was established called the Court of Common Pleas, which initially split from the Exchequer of Pleas and received official recognition in the Magna Carta. They just said in the 1911 Encyclopedia Britannica, the law practiced by the Berbers was the uncoded Magna Carta. Okay? So we have the Magna Carta as well as the Wittemont, which is where you got the King's Bench or the Kuray Regis, which are its predecessors. Okay? Indisputable. Which followed the king in the Common Pleas, which sat at Westminster Hall. Kuray eventually became known as the King's Bench, with the king himself required to be present for the court to sit. So the king must be present for the King's Bench to sit. Okay? Meaning the king and his court. All right? Very important for you all to understand that. Let's move forward. As we see here on New Jersey Court website, the origination of the common law, being one of the original 13 colonies, New Jersey has been strongly influenced by English law and the Anglo-Saxon tradition. The three branches of government enshrined in the United States Constitution and the New Jersey's Constitution are derived from the English history. The kings were the executive branch, Parliament, the legislative branch, and the court, the judicial branch. It was in the English judicial that a formal, civilized system for resolving disputes and addressing crime originated amongst the English-speaking people. It was in the early courts in England that the common law took root and evolved into our current system of court, judges, and juries. The common law, we know it today, dates back to the 12th, 13th century and derives from the reign of King Henry II, who appointed judges to resolve disputes among his subjects. We've been going over this for so long. And this was based upon the common law. Once again, the common law, we know it today, dates back to the 12th and 13th century, deriving from King Henry II, who appointed judges to resolve disputes among his subjects. It's on New Jersey Court's front page. All right? So let's go to New Jersey's Constitution, Article 22, which is on their website. State of New Jersey, Department of State. Go all the way down to Article 22. It states that the common law of England, as well as so much of the statutes law, or statutes at large, or statutes of the realm, which were the statutes of law originated from, as have been hereto practiced in this colony, shall remain in force until they shall be altered, by a future law of the legislature. Such parts only accepted as are repugnant to the rights and privileges contained in this charter, and that the estimable right of a trial by jury shall remain confirmed as part of the law of this colony without repeal forever. 23. You feeding them? 23. That every person who should be elected, listen, y'all, listen. Every person who should be elected, as aforesaid, to be a member of the Legislative Council or House of Assembly shall previous to his taking his seat in Council of Assembly take the following oath of affirmation. I do solemnly declare that as a member of the Legislative Council or Assembly, as the case may be, of the colony of New Jersey, I will not assent to any law, vote, or proceeding which shall appear to me injurious to the public welfare of the said colony, nor that shall annul or repeal that part of the third section of the charter of this colony which established that the elections of members of the Legislative Council and the Assembly shall be biannual, nor that part of the 22nd section in said charter respecting the trial by juries, nor shall they annul, repeal, or alter any part or parts of the 18th or 19th section of the same. And any person or persons who should be elected as aforesaid hereby empowered to administer to the said members of the said oath of affirmation, provided always in its true intent of the meaning of this Congress, that if a reconciliation between Great Britain and these colonies should take place, and the large latter, i.e., the colonies, be again taken under the protection and government of the Crown of Great Britain, this charter shall be null and void. Otherwise, to remain firm and inviolable. In the Provisional Congress, New Jersey Bulletin, July 2nd, 1776, Samuel Tucker, President. Okay, let's go back to New Jersey Provincial Council. Basic citizenship information, or information that the subjects should know. All right, vice versa. New Jersey Provincial Council, before it became the Legislative Council of New Jersey, was His Majesty's Council, which was the upper house of the New Jersey legislature under the colonial rule, until it was replaced by New Jersey Legislative Council under New Jersey's Constitution of 1776, which we just read for the record, that there would be a reconciliation of Great Britain, and once that's done, that Constitution, which we're reading now, created by New Jersey Legislative Council and New Jersey Provincial Council, was based upon the laws governed by the Crown. That Provincial Council was established in 1702 upon the surrender of the proprietary of East Jersey and West Jersey of the right of the government to Queen Anne. That was in the Proprietary House, which is seated in Perth Amboy, right where we're at now. That's where the Proprietary House was seated at, all right? And that's where the Crown was seated at. And the authority that was given by the Crown to the world governors, Viscount Cornbury, was by Queen Anne. And this government was called Queen Anne's government, in which united the colonies as a province of New Jersey, which was a royal colony, established a new system of government. The instructions from the Queen to the Viscount Cornbury, the first world governor of New Jersey, outlined a fusion of power system which allowed for an overlap in executive, legislative, and judicial authority. An overlap of the executive, legislative, and judicial authority. And provided a bicameral legislature consisting of a council and a general assembly. On December 6, 1775, Governor William Franklin prorogued the New Jersey legislature until January 3rd of 1776, but it never met again. On May 30, 1776, Franklin attempted to convene the legislature, but was met instead with orders of the New Jersey Provincial Council for his arrest. On July 2nd, 1776, that Provincial Congress approved a new constitution, and which we just read, Article 22 and Article 23, and on August 13, a new legislature was elected with the appointment of Provincial Council being succeeded by the elected New Jersey Legislative Council, which was succeeded by New Jersey Senate. Okay? By the New Jersey Senate. But it said right here that New Jersey Provincial Council changed from the Provincial Council to the New Jersey Legislative Council or New Jersey's legislator by way of the wishes of the new New Jersey Provincial Congress. Very important that you understand that. Why? Because that Congress was called a provisional government, a temporary government. Look at the words I'm telling you. Provisional or temporary. Why? Because the Crown government was not provisional, nor was it temporary. It said the length of the term is indefinite, and the authority of that indefinite government of the Crown was based upon the king. Okay? And you know, these kings who were sitting at this time were not kings of England. All right? Very important for you to understand that. Why am I saying that? That goes back to provisional government. A provisional government is also called an interim government, an emergency government, a transitional government, or a provisional leadership, which is a temporary government formed to manage a period of transition, often following a state collapse, a revolution, a civil war, or some combination of thereof. Okay? Provisional governments generally come to power in connection with a grave crisis that has caused the previous government to suddenly, irreversibly collapse, such as an economic collapse, civil war, defeat in a foreign war, revolution, or the death of a long-serving authoritarian ruler. Questions of democratic transition, you hear that? And state building are often fundamental to the formation of policies of such government. The 1911 Encyclopedia says that the government of the Berbers was a democratic government, all right? Not a republic government, not a Commonwealth government, because both of those are the same, which was instituted by the Scottish king. Prior to that, the government that was functioning at that time was called the government of the king, or his majesty's government, okay? Called the king and parliament, or the king and bench, or the king in his executive department, okay? We must understand what's going on. So we see a provisionary government was the result of a collapse in a prior government, okay? A temporary government was the result of a collapse in a prior government. Very important. We understand. Temporary government. Everybody say that with me. Temporary government. All right? We know the temporary government came about in 1776. But it's only temporary because they said it. If a reconciliation of the colonies take place and the colonies come back under protection of the government of the Crown of Great Britain, then this charter should be null and void, otherwise it remain firm and inviolable. So if the 1911 Encyclopedia said that the government of the Berbers was called Wittenmont, which we're reading here, and the uncoded law that they had was called the Magna Carta, and they never referred to them as Anglo-Saxons. And then we read here that the government of Witten or Wittenmont was the government of the Anglo-Saxons, right? As we see here, and these were the wise men or the wise council, where the King's Bench got their authority from, okay? Where the King's Bench got their authority from, because we know that the King's Bench or His Majesty's Council originated from Wittenmont, then became the Career Regents, then what you call now the King's Bench. Okay, so if that is the case, then it was only right for I, as the new king, to now adopt a new name to fit the parallel or premises that draws the conclusion that we are in fact the same people that were mentioned in the 1911 encyclopedia by incorporating the term Anglo-Saxon Berbers. Okay, let's see that. Article 4, members' job, our duty. The Magna Carta, Clause 1. Remember? Didn't it say the Berbers? Uncoded law was called the Magna Carta, and the government was called written, all right, or Wittenmont, all right, and we know that now is called the King's Bench, and we represent the King's Bench. It says here, the Magna Carta Clause 1 states that the liberties of the English Charter, first, that we have granted to God, and by their present charter, let me read that all over again. The Magna Carta Clause 1, the liberties of the English Church, first, that we have granted to God, and by this present charter we have confirmed for us and our heirs in perpetuity, that the English Church shall be free and shall have its rights undiminished and its liberties unimpaired, as the English king's heirs and successors, duty and allegiance, to restore the peerage, life, and history of the English Anglo-Saxon Berbers. Who? The English Anglo-Saxon Berbers. Who? The English Anglo-Saxon Berbers. Prior to that incorporation of the Berber into the English history known as Anglo-Saxon, based upon the government of Wittenmont, it was not known until as described in the 1911 Encyclopedia Britannica. Okay, so that is living prophecy that what they prophesied about who the Berbers was going back to the time of the government of Wittemont, of those wise men, that means that we are in fact indeed the same people based upon bloodline, ancestry, customs, laws. We have it right here. It's in our charter. All right. Why is this important? Politics of New Jersey. All these sources. History of New Jersey. The Constitution declared itself temporary and void if there was a reconciliation with Great Britain. All right? There go that word. Provisional government, temporary government, an intern government, if will be null and void if there was a reconciliation with Great Britain. Okay? There is a reconciliation with Great Britain based upon the incorporation of the state of New Jersey, which we see here. New Jersey Revised Statute, Title 52, State Government, Departments, and its Officers. Okay? Listen to the smarts of this king. All right? Under the statute 2023, all right? Trenton is the county of Mercer shall be the seat of the government of this state. All right. When they moved from Burlington County or in Perth Amboy, where we seated now, it moved to Trenton, and that became the temporary or provisional government, as we see here as established in the legislation. Okay. We see it here. All sessions of the legislature should be held at Trenton on a temporary basis for ceremony or commemorative purposes, All right, did you hear that? All sessions of the legislature shall be held at Trenton on a temporary basis. It didn't say permanent basis. It said a temporary basis for ceremony and commemorative purposes. All right. So that means that that government is provisional, and if it's a provisional government, it must have provisional officer. All right. That provisional officer is called a head of state. A head of state. Okay. And this is all of them. All of these are nothing more than commemorative officers. These are facts. A head of state or chief state is a public persona of a state or sovereign state. The specific naming of the head of the state depends on the country form of government and separation of power. You hear that? The head of state may be a ceremonial figurehead or currently the head of the government and more. Okay? So if the provisional government, as we've seen in 52:1-1 of the Jersey Revised Statute, says that the government of New Jersey is ceremonial and commemorative, then that means that the officer or the head person in charge or the chief officer in charge is only ceremony as well. And they're called figureheads. What is a figurehead? In politics, a figurehead is a practice of who the juror in name or by law appears to hold an important and often supremely powerful title or office, yet de facto in reality exercises little or no actual power. This usually means that they are a head of state, but not head of a government. Did you hear that? They are head of a state, but not head of a government. I mean, common sense for people who understand this common knowledge. If you don't understand this common knowledge, then you don't have common sense. And without common sense, that means you are ignorant of these facts. Okay? Very important. So a figurehead is one who is de facto in nature, having no power at all. And that's apparent based upon you being a head of state for a temporary government, which is a provisionary government with a provisionary head of state. Okay, very important. So we see the same display in New Jersey Revised Statute, Title 52, Title 52, :1-1. Trenton seat of government, location, and legislative session. And this involves the state government, its departments, and officers. I mean, every one of them. Okay? So if the government is temporary and the head of the government is temporary and they ain't got no power at all, that means that all the laws that they have for that government only pertains to the jurisdiction of that government, which is temporary. So if the government is temporary, the departments are temporary, the officers are temporary, that means the laws are temporary, right? That means the laws are temporary. I'm not saying that. This is what the legislative statute says for your government. Validity of act performed at emergency temporary location. During such time at the seat of government remains at such emergency temporary location or locations, all official acts now or hereafter required by law to be performed at the seat of government by any officer, agency, department, or authority of the state, including the convening the meetings of the legislature in regular, extraordinary, or emergency session, shall be as valid and binding when performed at such emergency temporary locations or location as it was performed at the normal location of the seat of government, which we know, based upon the Constitution, is temporary. Next, 52:1-3, contrary or conflicting laws. The provision of this act should control and be supreme in the event it shall be employed, notwithstanding the provision of any other law to the contrary or in conflict herewith as provided in Sec Title 52:1-1.3. So any law contrary or conflicting with the laws that remain valid for the government, department, its officers of the state of New Jersey, which is only a temporary government for ceremony and what it says for ceremony and what was the term it says? Commemorative purposes. Okay? Ceremony and commemorative purposes. So it means that the commemorative and ceremony purposes that were created for the visionary government or temporary government for the temporary government departments and its officers, and the laws that govern the department, the state, and its officers are only temporary. All right? They're only temporary. Why? Because there are some laws that conflict, which are contrary to their law, but they still say this law is supreme in the event that it shall be employed. Meaning that it wasn't effective until they employed the law for the new government that they moved to Trenton. Prior to that, there was a law already in place that was contrary or in conflict therewith. All right? Very important you understand the basic understanding of the part that you play in this body of politics. Right? Very important. Why is this important? Why is this important, King? Why is this important? Let's see. New Jersey Revised Statute, Title 2A, Administration of Civil and Criminal Justice, Section 2A 66-6, who may institute. Who may institute. A proceeding in lieu of a prerogative writ may also be instituted as of a right against any person for usurping, intruding into, or unlawfully holding or executing any office or franchise in this state by any person who, under the former practice, would have the requisite interest to exhibit an information in the nature or quo warranto with the leave of the court. Okay? So anybody who holds an office contrary to what the law says about how or who should be sitting in office has to be subject to provide information in the nature of a quo warranto with the leave of a court. Whose court? Either their court or the King's court. And first of all, the prerogatives that we're talking about, such as writs, originated from the King's court. Let's see. Nathaniel Ben Franklin Firehouse Insurance Company versus Camden Trust Company. Okay? 1956. Billings versus Harris also says the same thing. Okay? It also says the same thing. Look at what they say. Once again, let's look at the King's Bench again. All right? That goes back to the King's Bench. And the King's Bench has authority when the king is there to give a prerogative writ. Okay? The King's Bench, as we see here, or the court of the King's Bench, or the court and the king before the king himself, all right, which is in the case right now, origin goes back to the Curia Regis, and prior to that, it was called Wittemont, which was called the Anglo-Saxon Burbage, which we in fact are incorporated as Berbers. All right. So it's only right that a cor warranto be issued out in regards of the de facto office that the state of New Jersey, its departments and its officers have admitted by way of the statute that they are in fact uh, uh, um, de facto officers and they're in violation of their appointment as prescribed in Article 22 and 23 because they are not officers of the common law. So they have the right to be removed from office based upon the nature of a cor warranto because they don't have the authority to be in that office known as holding such a title. Let's see it for ourselves. The act can operate only within the framework of the Constitution. For example, the prerogative writ jurisdiction vested in the old Supreme Court of New Jersey, as stated in Billing versus Harris, as the successor of the King's Bench by the 1844 Constitution, was thus put beyond legislative impairment. So that means that they can do nothing about that, right? The Supreme Court was the sole depository of the prerogative writ of certiorari, writ of mandamus, and cor warranto. The distinguished feature of the King's Bench was the authority which it alone exercised by means of writs of certiorari, mandamus, cor warranto, and the 1844 Constitution, and was framed to perpetuate in our Supreme Court the same ample and exclusive power. See Flanagan versus Treasury of the City of Plainfield. Okay, so that means that the Berber people and the Berber Council or the King's Council made of Berbers have the authority to issue out writs of prerogatives based upon uh, 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 the nature of questioning that someone holds a title which was not lawfully granted to them. Okay? Such as they said in this case. For instance, the title to an office was tribal only by a writ and the nature of a cor warranto. Okay? And in that common law, the remedy for the dissolution of a corporation is by a cor warranto. You hear that, y'all? Did y'all hear that? But there is no occasion to go on. It suffices to say that the declaratory judgment was designed to enlarge the early common law conception of the judicial process as a means of remedying an actual violation of personal or private rights that ordinarily there is no occasion for invoking the measures where there is a wholly adequate remedy in the usual course of plenary suit for the prosecution of a cause of action that has reached the stage of enforcement and such is the relief sought. Okay? So for us, we have the right to use a prerogative writ because the origin of the prerogative writ is a right according to 2A-66.6 of New Jersey by statute. It ain't what they call discretionary. The writ is not discretionary because it says here in the statute it is a right. Okay? It said it is a right. Okay? A proceeding in lieu of prerogative writ may also be instituted as a right against any person usurping, intruding into a lawful, upholding, or executing officer or franchise in this state. What it says in 66-7. Judgment. If in a proceeding instituted pursuant to Section 2A-66-6 of this title, the defendant shall be found guilty of usurping or intruding into a unlawful holding or executing any such office or franchise, the court may give judgment of ouster against him and fine him. Did you hear that? Did you hear that? So all the officers of the state of New Jersey, of any department of the state of New Jersey, for the government of New Jersey, is a violation of Title 23 of the New Jersey Constitution of 1776, 1844, and 1947, because they all adopted the common law of England, and none of these judges, lawyers, officers of any department are members of the common law because they are not of Anglo-Saxon Berber descent. You hear that? Did you hear that? So therefore, once again, who may institute a claim? A proceeding in lieu of a prerogative may be instituted as a right against any person for usurping, intruding into, or unlawfully holding or executing any municipal office or franchise in the state by any person who believes himself lawfully entitled to such office or franchise. So I have the right to because I'm the one who has the right to be in that office by way of title, as they said in the case law. Right? They said it right here. The only instance for the nature quo warranto is to challenge a title to an office or remove or dissolve or bring a corporation to dissolution. It's by way of a quo warranto. Just look up quo warranto real quick. Just be on the topic. It's just a shame the cognition of our people. It is a shame. I'm gonna hold everyone accountable for what's being said on this platform. All right. Quo warranto. An English American common law. Quo warranto means in Latin by what warrant is a prerogative issued by a court which orders someone to show what authority they have for exercising some right, power, or franchise they claim to hold. The writ of quo warranto still exists in the United States, although it is uncommon, but it was abolished in England and Wales. How was it abolished in England and Wales, but yet it's here in the United States? That don't make no sense when the actual quo warranto originated in England. Okay, so I'm telling you that it was never abolished because over there was never England. That was called United Kingdom or Great Britain. Great, and all that territory over there was added to the territory here, known as what we call the Anglosphere. All right, don't let them teach you wrong. Early history. With the spread of royal justice in the 12th and 13th century, private franchise and liberties were increasingly called upon to uphold the king's peace and to act against malefactors and peace breakers, so that they may appear that you are a lover of our peace. From 1218 onward, world heirs also began using the old writs of quo warranto, a court order to show proof of the authority, as for example, by what warrant are you the sheriff to investigate the origin of said franchise? An inquest of 1255 began examining such liberties nationwide, and the same inquiry was taken up by who? King Edward I of the Plantagenet Crown. Okay? Of the Plantagenet Crown. Son of Henry III, the founder of the Plantagenet Crown, who descended down from John, and we know he was the founder of the Angevin Crown. Okay? We must understand this history. All right? All right. So the quo warranto goes back to Richard I, time immemorial, Edward I, father of Edward II, father of Edward III, the father of John Gaunt, that's where your King Henry VII and all the other de facto monarchs come in. All right. So it's very important you understand that in lieu of your position as part of the government, as well as your leader's position as a representative of the government, because if the leader don't take his position, then guess what? And you subject to the laws of a de facto government. All right? So this is why your king has taken the position in lieu of ordering a quo warranto to this criminal complaint filed against your king in lieu of a trial. Because only two things can happen. is 6 months already into the indictment process for to prove that I in fact committed a crime by way of filing the deed in lieu of the land that actually rightfully belongs to the king. All right, as a result of my title. All right, and those who are trying to stop me from that right of my prerogative according to my title are those who claim to have a title, which is an invalid title because those titles are not held by the common law of England as described by the common law of England versus Title 22, Article 22, and Article 23 of the New Jersey Constitution, all right, which was based upon the reconciliation of Great Britain, which was done through our incorporation of our religious society based upon our body politic, which is nothing more than what we call a government. Okay? A government. You must understand. Right? Everyone listen. August 14th, 2024. State of New Jersey versus King Clifford Jefferson. Complaint. There's a complaint number. Petition for writ quo warranto 2866-6-2024. Who may institute a prerogative writ? I should be able to. Hell, I'm the king, right? As either you either issue the give notice of this nature of this quo warranto to the respondents, or let this mess play out in front of a trial by jury. And I doubt you want to do that, because either way, they're gonna ask these questions of how they hold these positions that they hold. In lieu of claiming they have the authority to bring charges against me. Okay? Because the suit can't be sued in his own court for property that belongs to the king, and the court's obligated is to protect the king's property as well as the king. All right? So let's read this in closing. All right? Petition under Article 22, which we just read. So and don't act like you don't know what it means. It's already in the mail. One was sent to the Attorney General, one was sent to the Judge Colleen Flynn, and one was sent to the Public Defender. Okay? State of New Jersey versus King Clifford Jefferson. This is what was presented when they pronounced before the record. They was calling on Clifford Jefferson, and the public defender said, my client, King Clifford Jefferson. So right now, Clifford Jefferson is irrelevant. They got to deal with the king, because the judge did not challenge now one time King. He didn't say what that's an AKA name or doing business as. What do you mean by king? He never said one thing. So if he choose to say something, here's his time to say so. All right. If he denied his quorum warranto, that means that he have to prove that I'm not, in fact, who I say I am. And you can't do that because my certificate of incorporation says I am. You might not was familiar with that process of how to become a king. You thought it was based upon some folklore or myth that you were told by those who wrote this story. All right. But guess what? As I always say, he who writes your books sets your timeline. Time never was when we were not. As the life of time begin, the time will come when we be no more. And based off their time record that they said about us as Berbers, they said our government was here, always been here, and ain't going nowhere. Okay? So this is the petition as king, which is a right under the statute that cannot be denied under the statute if the statute says it's a right. And what better purpose than this quo warranto to be a right of than to be for the king? All right? Because lo and behold, in a criminal complaint, the witness said, referred to me as King Clifford Jefferson. That was their first mistake. Why would the only witness that you got refer to the so-called defendant as King Clifford Jefferson? So once again, you might not want to deal with it when I say it, but when you read that criminal report, it's going to say King Clifford Jefferson. So when that public defender said, my client, King Clifford Jefferson, that just ain't have nothing to say. He said, I'm not opening up that can of worms, and you will not be doing it in my courtroom today either, prosecutor, and you won't be doing it in that probable cause hearing, because ain't no probable cause hearing going to be heard in lieu of this court warrant or the order to show cause of how you able to do what you do, because I'm going to get the judge to step in and demand them to do it, because this is his safety net now. The judge is going to be obligated to grant this court warrant, which is right, which will relieve him of his obligation based upon that which was created by those who overthrew the government, which was based upon those who run in the Superior Court of New Jersey. Because if we go to Bellin versus Harris, it says here, all the power of the King's bench, it was long ago settled that the former Supreme Court, and I'm going to read it in closing, as established by the Constitution of 1844, was vested with all the powers of the King's bench. The King's bench was called the Cray Regis, and the Cray Regis was called Wittemont, which was the council of wise men known as Berbers, now called Anglo-Saxon Berbers, through our certificate of incorporation. And they said here that it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's bench, which the legislature was powerless to cut down, as they said in the Daniels case we read a second ago. All right, the legislature was powerless to cut down or to assign to any other court. But what did they do? They assigned it to the Superior Court, where is that right now? Okay, it's in the Superior Court, and the Constitution, the legislature said you were not able to do that. Let's see what legislature said you couldn't do it. Let's read it. New Jersey's first constitution, adopted July 2nd, 1776, terminated its status as an English colony and began its sovereign existence as a state. Article 22, which we just read of that constitution, continued the common law. 23 was the oath of affirmation to that common law, as well as understanding that there was a temporary departure from England, i.e. the crown. Why? Because it was being overthrown by those British monarchs sitting on the crown, called at that time Great Britain, through the Treaty of Union of 1707. So that constitution was replaced by the Constitution of 1844, modeled largely instructed in content on the Constitution of the United States, meaning that they're equal, by Article 10, paragraph 1, and it too continued to enforce the common law as established in Article 22 of the 1776 Constitution, as well as at the existing courts of laws and equity, i.e. Chancery or probate. So also the current Constitution of 1947, by Article 11, Section 1, paragraph 3, continue to enforce all existing laws. And it was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's bench, which the legislature was powerless to cut down or to assign to other courts, but yet they did it anyway. This principle is especially shown in the field of prerogative, which the writ circulator is one. I didn't use that one because when you ask them to certify that, they're not going to do it. Why? Because they know damn well it was wrong from the door. So a court warrantor is the only remedy you can seek in regards to not really letting the judge to resolve the issue, but letting them resolve the issue by coming on the record and stating for the record how they get their authority. All right? And we said that this can only be done by a prerogative of court warrantor and the nature of a court warrantor. And it said, these prerogative writs, with the court warrantor, writ amendments, as well as the writ circulator, or you call a petition to certify, these complexities of these prerogative writs became technical for those who are now sitting in these judiciary positions as a result of them being administrative justice by way of the Administrative Procedure Act that came through the re-amending of the 1947 Constitution, which has just said that all the laws that were there prior to that were still in place. So guess what? Now they're in trouble. Why? Let's go back to the petition. 1, King Clifford Jefferson petitioner. 2, State of New Jersey respondents. Petition under Article 23 of New Jersey's Constitution of 1776 and New Jersey by Statute 2A66-6, 2024 statute. To Honorable Colleen Flynn, Judiciary of Superior Court of New Jersey, Courtroom 501. The Honorable Justices and his companion judges of the Honorable Court. The above named petitioner submits as under. The petitioner has lawfully incorporated as corporation sole, which is a legal entity called the Crown, consisting of a single sole and incorporated office occupied by a single sole natural person. This structure allows corporations, often religious corporations or commonwealth government, to pass without interruption from one office holder to the next, giving positions legal continuity without subsequent office holder having identical powers and possession to their predecessors, pursuant to New Jersey by Statute 16.1-43.7, 8, and 9. Only put 9 there, but we can go to 7 and 8 if you want to. Point 2. The Crown broadly represents the state in all its aspects within the jurisprudence of the Commonwealth realm and their subdivisions, such as Crown dependencies, overseas territories, provinces, or estates. Why? Because the land is allodial. The term refers to the office of the monarch or the monarchy as the institution, to the rule of law, or to the function of the executive, the Crown in council, the legislative, the Crown in parliament, and judicial, the Crown on the bench, governance and civil services. 3. Supreme Court of New Jersey and Nathaniel Ben Franklin Fire Company, Insurance Company versus Camden Trust Company. We just conferred that what Billy versus Harris said, they said the same thing, that the only way that you can petition was based upon through the King's Bench. That was verified in the 1770s Constitution, the 1844 Constitution, and the 1947 Constitution. And in this case, in point 3, they said Supreme Court was the sole dispository of the prerogative writs of certiorari, mandamus, and quo warranto. The distinguishing feature of the King's Bench was the authority which is alone exercised by means of the writs of certiorari, mandamus, and quo warranto, and in the 1844 Constitution was framed for the perpetuate in our Supreme Court and the same ample and exclusive power, which you now transfer to Superior Court. So when the Superior Court do get this letter, they're going to be open for an eye awakening. Why? Because the precedent that is based upon clearly says that this matter is a matter of the King's peace. Why? Why is it matters of the King's peace? Because it's based upon a title trying, for instance, the title of an office was triable only by writ and the nature of a quo warranto, as well as the common law. The remedy for a dissolution of a corporation, such as the state of New Jersey or any state within the union, is by also or quo warranto. And this is the reason why I'm using these two cases to validate the precedents based upon my right to them to issue a nature quo warranto to those who bring claim against the king and his own court with his own laws and his own judiciary and his own legislation. Who the hell are you to bring me in court when you are my court based upon what the Supreme Court just said in Billy versus Harris, which I'm not going to repeat because we read it. All right? 5. The petitioner has approached this honorable court seeking an issuance of a writ of nature quo warranto against respondents number 2, questioning such appointment pursuant to Title 52, State Government Department and Officers. 6. Straight to the point. Straight to the point. New Jersey Revised Statute 52:1-1 clearly verifies Trenton in the county of Mercer should be the seat of the government of the state, and B, all sessions of the legislature shall be held at Trenton or on a temporary basis for ceremony and commemorative purposes. 7, 52:1-2 clearly says that all the laws created in that jurisdiction, which is temporary for the government, departments, officers, are valid. Where is it at? Valid and binding when performed at such emergency temporary location. Okay? 8. New Jersey Revised Statute 52:1-3 says the provisions of this act shall control and be supreme in the event they shall become employed, notwithstanding or which means that besides or notwithstanding or what else? Regardless of the provision of any other law that's contrary or in conflict with the laws that they just created for their new temporary government, for their temporary departments, for their temporary officers, and their temporary laws. Okay? So as a result of that, it all being temporary, which is provisionary, which we just read, was to prepare for royal rule. 9 states that the petitioner submits that the selection and the appointment of respondents number 2, the whole state, their departments, their officers, including that prosecutor who's trying to sue me, is a violation of the provisions of Article 22 of the 1776 Constitution, the 1844 Constitution, and the 1947 Constitution, as we just read in Billy versus Harris, and Nathaniel, that case we just read. that every person who shall be elected as aforesaid to a member of the legislative council or house of assembly shall previous to his taking his seat in council or assembly shall take the following oath, i.e. pledges of allegiance. Okay? So they took their pledge of allegiance based upon the common law, which is based upon the Constitution, but yet their Constitution that they go by had nothing to do with the common law. Why? Because it was amended so many times. All right? Point so. That brings us to 10. Provided always that the true intent and meaning of the Congress, their departments, their agencies, their laws are only temporary based upon what they stated in the Provisional Congress, that if a reconciliation between Great Britain and these colonies should take place, and that the latter be taken under the protection and government of the Crown of Great Britain, which I said I incorporated as the Crown in point 1. I stated that through my certificate of incorporation. That means that that charter of New Jersey and any charter of the Constitution of any state within the United States is null and void, because at that time there was a United States, it was only colony. All right. And this was signed off by the president of that Provisional Congress, Samuel Tucker. Okay. Samuel Tucker. In closing. 11. That the petitioner, number 1, has a criminal case filed by the respondents, number 2, and they are persons of doubtful integrity, and therefore said persons are not to have been appointed on the said post and appointment, which is legally unsustainable and is a violation of statutory provisions as prescribed by New Jersey Revised Statute 2A66-6, 2024 Revised Statute. 12. New Jersey Revised Statute 2A66-7 clearly says that a proceeding in lieu of prerogative may also be instituted as a right against any person for usurping, intruding into an unlawful holding or executive or executing any office or franchise in the state by any person who, under the former practice, will have the requisite interest to exhibit an information and the nature of quorum warranto with leave of the court. I'm telling the court to issue a quorum warranto because the offices that they hold are in violation of the laws prescribed by the Crown. Okay? How I know that? Because I represent the Crown. I know the Crown is represented by the King's Bench, and the judge is not the member of the King's Bench. So if he want to save his ass, he better do what I say. If it's not, he gonna find out and come out in that trial, and guess what? All of them gonna go to jail. All right? So choose your doom, because definitely this is doomsday book. Point 13. New Jersey Revised Statute 2A66-6. A proceeding in lieu of prerogative may also be instituted as the right to anybody who's usurping a office on the municipal level. Okay? You see that? The state level or municipal level, because the federal government already knows it there. All right? They know that there. 14. That respondent number 2 is not a person of ability, integrity, and standing who has an adequate knowledge of and has shown capacity in dealing with problems relating to the common law of England. Did y'all hear that? Did y'all hear that? Therefore, such election and appointments deserve, pardon yourself, something right here. Right here. 14. All right. That respondents number 2 is not a person of ability. Because remember, they are a legal person. They're not natural person. I'm a natural person. All right? The Crown's a natural person. They're a legal person. That means that they're aggregate. And based upon Chisholm versus Georgia, United States versus, was it Chisholm versus Georgia, it clearly said that the only person who creates corporation is the king. And United States, as well as the states, are subordinate corporations as stated in that case. So as it's stated in 14 in closing, that respondent number 2 is not a person of ability, integrity, and standing who has an adequate knowledge of and has shown a capacity in dealing with problems relating to the common law of England. Nobody in that court has, because they know that all the laws in that court is rooted in the common law of England. All right? Therefore, such election and appointment deserves to be squashed, being contrary to the statutory provisions by issuance of a writ in the nature of a quorum warranto on my behalf, i.e., your king. 15. Therefore, the petitioner submits that a writ of nature in quo warranto is issued by the court on the following grounds. A, that the appointment is a violation of Article 23 of New Jersey's 1776 Constitution, and B, that the appointment is unsustainable and illegal at law. 16. The earliest provisional government, which we talked about a little while ago, were created to prepare for the return of royal rule, irregularly convened assembling during the English Revolution, such as the Confederate of Ireland, which was described as provisional, the Continental Congress, a convention of delegates from the 13 British colonies on east coast of North America, which became provisional government of the United States in 1776 during the American Revolution. The government shared its provisional status in 1781 following the ratification of the Articles of Confederation and continued in existence at the Congress of Confederation until it was supplanted by the United States Congress in 1789. Why did you do that? Okay? Why did you do that? All the other presidents you already know. I'm not going to go through that because I just read these cases. I'm going to go through here. So the prayer that I want in regards to this matter, Kelly says, oh, damn. I put it right in her face. You can go right there on the New Jersey website, court, and you see that everything I'm talking about is right and exact because you got it on the New Jersey court website in 2024. So if you don't want to go look now, you will look through trial, okay? If you don't want to take this encyclopedia to trial either, because it's going to tell you that the written government, which is called the King's Bench, which was incorporated in the court you're sitting at now, which is based upon the uncoded laws of the Magna Carta, comes from the Burbage, which we are incorporated. So therefore, you either give me my prayer through the quo warranto or give me my prayer through a trial by jury. Why? Because in the facts and circumstances stated above, the petitioner prays that a direction in the form of a writ quo warranto or any other appropriate writ be issued for the subsequent removal of respondents, number 2, from the post or appointment within their provisionary government and restore the prerogatives of the crown. Note, please confirm that you have received this fax, and I didn't even fax it, I mailed it by using any method below. If you have any questions surrounding the nature of this request, please contact us and don't hesitate at my number or my email or the Third Communal Church of England through our website. His Majesty, with his royal signature, as well as the signature, well, not the signature, but of the public defender, in case he got something he want to say. All right? Because apparently you ain't going to do this because you know to do this, the judge is going to look at you like you crazy. So I relieve you of that duty as a result of you taking the position as being that de facto officer. So he himself got a choice to make as well with that judge. Okay? He got a choice to make as well with that judge. So in closing, please understand the strive that I've taken as a king to bring back a government with the juror laws to be able to once and for all put us back in the illustrious estate within a realm that was created by our ancestors who was of the illustrious of state, because why? They were the wisest of all men. And these men were called in that present time, as we are in this present time, the lost but now found Anglo-Saxon Berbers, and realizing that we will return New Jersey capital to the crown, which was the stolen secret that I have just revealed to you in this present day. And with that, I greet you as I always meet you, and that's always in peace and love.